Good day, and thank you for visiting my channel, Coin Lady. Ripple's XRP chief denies settlement rumors and lays out plans for the future. As Stuart Alderoty elucidates the ongoing SEC against Ripple case, the rumor mill regarding a pre-trial conference in the SEC complaint dies down. This puts a damper on any potential settlement discussions. There was a lot of optimism among XRP members that the conference would finally bring a stop to the protracted legal battle. The court scheduling order from last year states that Magistrate Sarah Netburn will preside over the last pretrial conference. According to Alderoty, the pretrial conference was supposed to signal that the lawsuit was nearing a settlement, but that was put to an end by Khaled, chief legal officer of Ripple's, after the SEC dropped all charges against individual defendants Brad Garlinghouse and Chris Larson. The last scheduled pretrial session was cancelled by Chairman Alderoty. As for the subsequent stages in the SC case, the Ripple Club also discussed them. Alderoty reports that Ripple will reply to the SEC's remedy brief, which sought a fine of about $2 billion. The motion will be submitted under seal, but it is expected that a redacted version will be put in the public docket. This is an important note. At a later point, Alderoty brought up the fact that the SEC will also file its answer to the dispute over the settlement that Ripple's had started. According to the source, there has been a lot of talk about settling the SEC Ripple case recently. The parties concerned had already called a settlement meeting. No one knows what happened at the meeting, but some excerptionados think a resolution in the case might materialize shortly. These rumors have already taken root prior to the recent April 11th closed-door meeting of the SEC, as of the time of publication. One of the many reasons why the SEC versus Ripple case is probably over, according to popular XRP user Ashley Prospero, is the delay of the payout of 500 million XRP from escrow. The 500 million XRP that were released from escrow were intended to be part of the 1 billion coins that were going to be issued this month. Rumors surfaced among cryptocurrency investors at the time that Ripple was manipulating the stock market to pay for its SEC settlement. A problem with the escrow address prevented the system from unlocking all 500 million XRP on April 1st. Nonetheless, the remaining 500 million XRP were unlocked. Waves, the solution to the sexiest remedy, as well as Aldo's recent tweet putting an end to the widespread settlement rumors, have taken the stage. The only parties entitled to disgorgement are institutional clients that incur losses as a result of their XR purchases. Based on a case from the Second Circuit, as per Ripple's, an interpretation of a finding in the SEC versus Gulf of litigation has been made. Institutional investors that bought XRP at a price greater than its current market value will only have to pay disgorgement if the judge rules in Ripple's favor. Consequently, a number of legal experts who are keeping tabs on the matter have viewed the current speculation about a possible settlement between Ripple Labs and the U.S. Securities and Exchange Commission with skepticism and outright dismissal. This is due to the fact that a recent court ruling required Ripple to provide comprehensive financial records related to its institutional sales of XRP, and the SEC is demanding a massive $2 billion fine for Ripple. Something fresh has changed. Unintentionally, this decision has fueled speculation about a possible settlement. The legal processes have been delayed by 8 days due to a recent court directive made by Judge Sarah Netburn. There has been much speculation among observers about a potential settlement because this has given Ripple more time to fulfill the requirements for financial disclosure. However, there is still no clear resolution to this story, so there will be a cloud of doubt over the next few months, even if the deadline for remedy stage rebuttals is planned. Reasons why a settlement between SEC and Ripple would be meaningless. The settlement allegations have been vigorously denied by legal figures inside the XR community, who have disproved them. An experienced attorney by the name of Bill Morgan emphasized the need of keeping settlement conversations private, saying that some may be unaware that such discussions are secret and protected by law. Some may find this difficult to understand. There is, therefore, no sign that a settlement will ever be achieved until it is suddenly reached. Equally knowledgeable in the law as Morgan, Jesse Hines, strongly agreed with her remarks. Dismissed the rumors as unfounded. Until a settlement occurs, rumors of a settlement between Ripple and the SEC are meaningless babbling. In the rare cases that they do become public knowledge, it is usually disguised as a power play to gain leverage. Do not put your trust in the gibberish, Hines added. The discussion was tempered by the cynicism of former securities lawyer Mark Fogg, who poked fun at the possibility of leaks in such high-stakes judicial processes. As a matter of fundamental courtesy, whenever I was involved in litigation with the Securities and Exchange Commission in the past, he would always make sure to contact an anonymous and trustworthy Twitter account before starting settlement negotiations. In his response, Fogg emphasized how improbable it was that confidential material would be leaked. Morgan went on to say that in 26 years of settlement negotiations, during which she had participated in over 100 mediations as a mediator or lawyer, not a single one had ever leaked information or violated the confidentiality agreement that was a part of the process. Starting in December 2020, when the action was first filed, Ripple has faced significant legal obstacles. The company's institutional sales of XRP have been under scrutiny by the Securities and Exchange Commission, SEC, even though the XRP market has been negatively affected by the unstable regulatory climate. Important victories have been achieved by Ripple in these cases. Both the court's ruling that XRP is not a security and the dismissal of the SEC's case are examples of this. The lengthy legal battle that Ripple Labs and the U.S. Securities and Exchange Commission have been involved in may soon come to an end, according to rumors that a settlement has been struck against Ripple executives Brad Garlinghouse and Chris Larsen. The XRP price has continued its downward trend, which began over a month ago, falling by almost 3% in the last 24 hours, notwithstanding these rumblings. However, investors hoping for a cryptocurrency rally to coincide with the much-anticipated Bitcoin halving event could find some solace in the fact that a settlement is in the works, as the outcome of the case brought by the Securities and Exchange Commission (SEC) could signal the return to the cryptocurrency's previous shape. With the SEC case starting at the right time, Ripple and the SEC may have reached a settlement agreement, and Ripple XRP is aiming to reach 60 cents in April. The two groups have been involved in a major legal battle for the past few years, with Ripple having emerged victorious on multiple occasions. Thank you for watching my channel and for subscribing. I'll see you later.